privacy and to submit recommendations to the government in the field of informational privacy. So the Government of India, pursuant to this Supreme Court directive, formed a committee under the chairmanship of Justice B.N. Shri Krishna. This committee carried out detailed study of the privacy regime, and at the same time balancing the progress of the nation and suggesting a draft of legislation in 2018. Thereafter, in 2023, after multiple iterations of the Act, multiple considerations in the Lok Sabha, multiple considerations before the Standing Committee of the Parliament's both houses, the Act took a final shape, and 2023, it was given assent by the President of India, and it took current form of the Digital Personal Data Protection Act.
They have not written the correct name.
Sorry, there is some disturbance at some. Yeah. Thereafter, in 2023, though the Act was enacted, it was not made enforceable. And in 2025, the DPDP rules were notified. The DPDP rules contain provisions regarding detailed iterations of the certain provisions of the Act, as well as it contains timelines. So the Data Protection Board, which is constituted under the Act, became immediately operative after the notification of 2025 rules. However, most of the provisions of the Act which require the data fiduciaries to comply to the provisions of the Act will become operative within 18 months from November 2025, which is May 2027. So May 2027 is the date on which all the provisions of the Act will become operative and the Act will go full-fledged. So from today, there is a timeline of 15 months for complying with the provisions of the Act. However, though this timeline may seem longer, it is necessary to understand that the entire pathway to implement the DPDP provisions and to be compliant is not a very short span pathway. It is a comprehensive exercise. It goes to the root of the practices which the hospitals follow, and therefore it is extremely necessary to become alert and to come in action right from today, so that at the end of 15 months we are prepared to comply with the provisions of the DPDP. Now, to whom the Act is applicable? This Act is applicable to digital personal data, which I will explain what is digital personal data in my later slides. So digital personal data processed within the territory of India. It is also applicable to data collected in a non-digital form, but digitized subsequently. So if it is collected only in non-digital form, the Act is not applicable. The moment the data gets digitized, the Act becomes applicable. And also to data processed outside the territory of India, if it relates to the data principles within the territory of India. So if the person to whom the data relates is within the territory of India, it is immaterial whether the data is processed in India or it is processed outside India. The Act is not applicable to non-digital data. It is not applicable to data processed by an individual for personal or domestic purpose. It is also not applicable to data made publicly available by the data principal or by any other person who is under a legal obligation to make it publicly available. For example, if I post something on Facebook or Instagram, which is my personal data, and I make it publicly available, and it comes in public domain, then the data which I have published is not protected under this Act. Then this Act is applicable to processing of the data. So this definition of processing is a very wide definition. As you can see at the right side, it covers the collection, recording, organizing, structuring, storage, adaptation, retrieval, use, alignment, combination, indexing, sharing, disclosure, transmission, dissemination, making available, restriction, erasure, or destruction by wholly or partly by automated operations. So this virtually covers everything. I think in any form, in whatever form we deal with digitized personal data, it comes within the ambit of the Act. Now, there are certain key definitions under the Act. The Act deals definitely with data. So, what is data? Data means any representation of information, facts, concepts, opinions, and or instructions. So, it need not be necessarily information. It can be all of this or either of this. Then personal data means the data whereby an individual is identifiable. So suppose my name is Dr. Amitkumar Khatu. It is not enough. Dr. Amitkumar Khatu can't be my personal data. That is because there may be multiple Dr. Amitkumar Khatu and there may be several persons known by this name. However, my name combined with my Aadhaar number, or if my name is combined with my PAN number, then it becomes unique and whereby I am identifiable. So personal data means data by which an individual is identifiable. Then what is digital personal data? Digital personal data means that personal data which is in digitized form. By digitized form, it means which is in the form of soft copies in the computers or in the systems of individuals or organizations. Data principle. So this is very interesting that this act deals with the people who own, the person who owns, individual who owns the data. It calls him as a data principal. Earlier in GDPR, it is called as data subject. So subject is a term which is used in the domain of, say, empires, where there is a king and there are subjects of the king. So GDPR deals with the owners of data as data subjects, which are the citizens. However, the DPDP Act designates the owners of data as data principals, so which is a higher recognition given to the owners of data. And data fiduciary. GDPR deals with this definition as data controllers. So the person who controls the data is data controller. However, in DPDP, it designates the person who controls the data as the data fiduciary. By word fiduciary, it is meant that the data controller is looked up in a capacity of a trustee in whose hand the data is given. And it is his duty to take care of the data as if the trustee takes care of a public trust. So that the ingredient of trust is embedded in this definition of data fiduciary. And who's data processor? Data processor is the person or the entity who processes the digital personal data on behalf of the data fiduciary. And data fiduciary determines the purpose and means of digital personal data. So in case of hospitals and healthcare providers, the hospitals who collect the data from the patients and who determine the purpose and the means of processing that data will be data fiduciaries, and the vendors of the hospitals with whom the hospital shares the data and who process the data on behalf of the hospitals will be data processors. Then what is personal data breach? So this is very important. So this personal data breach means unauthorized processing or accidental disclosure. So this is very important. So accidental disclosure is also covered. So you can't take the pretext that it was disclosed accidentally. No, you are bound to protect it. Even accidental disclosure is a personal data breach. Accidental disclosure, acquisition, sharing, use, alteration, disclosure, or loss of digital personal data compromising the confidentiality, integrity, or availability. If this is caused to the data, then it's a personal data breach. And a new concept which is introduced by this act is consent manager. Consent manager will be a entity registered with the Data Protection Board and who manages the consents for data principals through a platform. So this will be a new area of business a new domain wherein entities can register themselves with the Data Protection Board of India, and they can take care of managing the consents on behalf of the data principals. Now, in relation to hospitals, what are the rights of patients under the Data Protection Act? So the rights of patients is right to access the data. Patient who hands over the data to the hospital will always have a right to access his personal data, right to know the purpose of processing. He will have the right to know for what purpose the hospital is processing the data, right to correction and update. It's not that once the data is given, it is the hospital's ownership with the data. No, the patients will have the right to correct the data which they have given and to update it from time to time. Right to erasure and withdrawal of consent. Patients will have right to withdraw their consent and to make the hospital to erase the data from its systems. The right to grievance redressal. They will have right to raise their grievance to the in-house grievance officer of the hospitals. Also, with the Data Protection Board, where the grievance is not addressed by the data fiduciaries. And also the right to nominate. Like we nominate our nominees in case of properties, the data principals will have the rights to nominate their nominees in case of their data. And the nominees can administer consents and deal with the data on behalf of the data principals. And what kinds of data the hospitals handle daily? Since majority of you are from healthcare sectors, you always know that hospitals handle data coming from OPD registration records, then prescriptions, diagnostics, HMIS entries, medical records, WhatsApp messages, which various groups within the hospital fraternity keep sharing with the consultants or with the nursing team or with the residents or with the admin team. So those WhatsApp messages are also the means of sharing personal data for hospitals. Emails, appointment reminders, marketing leads, old spreadsheets, that is Excel sheets stored in your computer systems, website data, the analytics, insurance billing and TPA records, staff HR data, vendor data, any other digital personal data which the hospital handles. Now, here I'm dealing with some 11 incidents which we normally come across in a hospital's life. And these incidents uh, expose us to the breach of personal data and may invite consequences. For example, a blurred consent. What is a blurred consent? You obtain a consent of the patient for treatment, and later that consent is utilized for marketing of your another service. So you have the data of the patient, and then after the patient is treated, he is discharged, he goes home, he gets recovered, and you contact the patient marketing your another service, like for example cosmetic service. That is not allowed. That will be no longer allowed under the Data Protection Act, because it is not what for which the patient had given you consent. So this consent is not a specific and purpose bound. We'll have to obtain separate consents for treatment and marketing, maintain digital consent logs. So what necessarily needs to be done, that the consent should be obtained in a digital format, and it should be recorded for what purpose the consent is given and for what purpose it is not given. And it should be easily enable to easily withdrawable, and withdrawal mechanism should be implemented in case of consents. Data overreach. Suppose physiotherapy clinic is there within your hospital, and the physiotherapy clinic is collecting mother's maiden name, which is unnecessary collection. So this is data overreach. There is a principle of data minimization. So this act is based on certain principles. So data minimization means only that data which is necessary for treating that patient or for the purpose for which he is sharing data, only that kind of data should be collected. Unsecured spreadsheets. As a practice, we maintain various Excel sheets, pathology lab, or storing patient list on a shared desktop, And we email accidentally certain spreadsheets which contain the patient's name, patient details, any information by which the patient is identifiable. If that is unsecured and it is not given access to specific people who actually require to have access, it is a risk. Henceforth, EMR vendor breach, external EMR server cyber attack, hospital is held accountable. Suppose we store our EMR data on an external server, and that external server gets a cyber attack. In that case, since the patient has shared data with hospital, the hospital is liable to the patient for the security breach committed by its vendors. So that is what we may face under this act. WhatsApp group report sharing. An assistant of a doctor sends patient blood report from personal phone to WhatsApp group. It is not allowed anymore. It is if a specific consent is required that it will be circulated in such groups and such individuals, then it will be valid. Otherwise, sharing someone's personal data, digital personal data from your personal mobile phone will be a breach. Then lost laptop. Certain information is stored in a laptop and that laptop is lost. Then billing data, if it is stored in a personal laptop and laptop is stolen and patient's information is disclosed through that theft of a laptop, it's a notifiable data breach. And in that case, what is the recommended solution? Mandatory device encryption we should have. We should have remote wipe capability. We should be remotely able to wipe the data from that laptop. Central server storage should be there. Incident response SOP should be there as to how we should intimate this incident of breach to certain and also to the data principal. And now after the act becomes enforceable, it is also required to be intimated to the Data Protection Board of India. Then new product promotion. Old patient data is used for new product promotions. That is no longer allowed because the patient has not given consent for that use. Website form without consent notice. So in our websites, there are appointment forms. There are certain forms by which the patient comes in, and there are certain fields which fetch the data and they provide the data to external analytics service provider or to behavioral patterns mapping service providers. That is no longer allowed. If it is to be done, specific consent has to be obtained from the patient, and so such consent forms and notices should be available on the website and they should be embedded in the form which the patient is required to fill. Privacy policy should be robust and which should be linked to that consent form which the patient fills on the website. Facebook pixel, marketing analytics tracking. Suppose infertility page visit data is shared without explicit consent. So there is a page on your website which deals with IVF or infertility, and someone comes and fills in that form, and suddenly he starts getting advertisements on his Facebook page regarding infertility clinics. So that is a breach because your website has given backend information to Facebook, and then Facebook has started showing those advertisements to that patient. So that's a breach. Failure to dispose of data. So if a data which is more than prescribed period, older than a prescribed period, certain OPD data or IPD data is required to be maintained for certain time. Even the medical legal data is maintained for perpetuity. However, if the data is not fitting in the category in which it is legally required to store for a certain timeline, and still if it is stored, then that's a failure, that's a breach under this act. Unsecured scan folder. So it happens very rampantly in hospitals that multiple medical records are scanned and they are stored in a desktop folder or my computer folder, which is unsecured. And anybody has access to those folders wherein majority of the patient's data is dumped. That is no longer allowed because it's personal data of the patient. And those folders should have limited access by the people who are actually required to have access. to those folders. So those were certain breach incidents. Apart from that, there are multiple breach incidents which may occur in a hospital's life. However, what does this DPDP Act mean for hospitals? Data protection is not an add-on feature. So we should be mindful that it is not just that we will have this add-on feature in our information systems or HIMS systems, but this should be a embedded feature in the digital DNA of hospitals. So the hospitals should become aware that this is not just an add-on feature to comply. This is a requirement which around which henceforth the digital architecture of the hospital should be designed. Not only hospitals, but the digital architectures of all healthcare providers, whoever are collecting and processing personal data, their digital architecture should be designed around the principle of privacy. Till date, what had happened is we had misinterpreted privacy with cybersecurity. We think that this is a work of the IT team of the hospital to protect the personal data. It's not their domain. Their domain is to protect the information of the organization. So the CISOs and the IT officers of a company largely protect the information of the company from external attacks. They create firewalls, they create protocols whereby the company's information is protected. However, this act deals with the information of individuals. Hospitals unfortunately think, hospitals and the doctors and the consultants, that the data which the hospital possesses is the data of the consultant or the hospital. It's not their data. It is the data owned by the person and the patient to whom the data relates. And we are the protectors and trustees, fiduciaries of that data. So the architecture should be designed in such a manner that the feature of privacy is an embedded feature. It's not an add-on. It's not just a fancy practice to comply with privacy laws. It has to be embedded. What the hospitals process, I have already dealt with this. Then what they face if there is a breach. They face penalties which may range up to 250 crore per violation. I will deal with specific penalty page. Slide is there. Then compliance trigger is May 27, as I already discussed. Hospitals may face stronger scrutiny because they deal with very sensitive health data. Then there may be operational disruption if cognizance of a breach is taken by the Data Protection Board and inquiry is initiated by the board. However, there also lies an opportunity for the hospitals to enhance their image by implementing robust provisions of data protection, by gaining patient trust and loyalty enhancement. Internal data process alignment can be done. This is an opportunity to realign the processes. Adherence to the best global practices. We can adhere to GDPR and HIPAA practices, which are reflected in the DPDP Act. Then there is an opportunity for brand upliftment through this Data Protection Act. Then consent. This is a very important concept under this act. Till date, hospitals have dealt in informed consent in relation to treatment. So the patient or the next of kin of the patient has given consent to the treatment and consequences of the treatment. This is what we have dealt till date. Henceforth, the patient's consent shall be very specific. They must know what data is collected and why it is collected. Separate consent for treatment, communication, marketing, and other purposes. The other day, I was discussing this aspect of consent with one of the CEOs of healthcare organizations, which is one of the large organizations, and he expressed that this is not practical. You can't have multiple consents of the patient for every purpose. But I think that is possible. It is not required to have multiple consent forms. It is required to have crisper, smaller consent lines or checkboxes in one consent. You can contain multiple consents in one consent form. However, they should be very clearly separate, identifiable, and crisper. They should not be very long, which cause there is something called consent fatigue. So the reader of the consent form should not feel that what am I reading and I'm not getting anywhere. So they should be crisp and short and sweet. Implied or bundled consent is no longer sufficient. Consent must be withdrawable. Consent should give right to grievance redressal. These are actually the ingredients of section 6, which deals with consent. Then consent should be free. Consent should be specific. It should be informed. It should be unconditional. It should be unambiguous. And it should be with a clear affirmative action signifying an agreement. So these are the requirements of consent under the Data Protection Act. It requires that whenever you request for certain information from a patient, you should give him a notice. And notice has to have 3 ingredients. First ingredient is notice should have the purpose for which the data is collected. Notice should be should inform that your consent is withdrawable, and it should also give him the information regarding the grievance mechanism within your organization, as well as he may raise grievance to the Data Protection Board of India. So these ingredients should be present in the notice. Then there are certain legitimate uses which are the exceptions to consent. So data can be processed with consent and data can be processed without consent for these purposes. What are these legitimate uses? If the data principal voluntarily provides personal data and does not indicate that he is not consenting. So he provides the data and he doesn't indicate that he doesn't have consent for the purpose for which he is providing the consent. Then functioning of a state in the interest of sovereignty, integrity of India, or security of the state. For this purpose, if the state is collecting data, it is not required to take consent. Fulfilling any legal obligation to disclose information to the state. Suppose there is a accident case, and if police come to the hospital and police take data of the patient from the hospital, in that case, patient's consent is not required because that's a legal obligation. Then compliance with judgment, decree or order of a court or tribunal. Medical emergency. Suppose a patient comes in emergency ward and there a certain data is required to be collected and processed. There you don't need consent because there is a threat to life or health. However, it does not, that part ceases when the patient is stabilized, he's transferred to your IP floor and the patient starts getting treatment, he's out of danger. In that case, the data is no longer required for his threat to life or health. In that case, the consents will have to be obtained. Providing medical treatment or health services during epidemic or public health threat. Under such scenarios, the consent is not required. Ensuring safety during disaster or breakdown of public order. For employment-related purposes, attendance, payroll benefits. So employees related data collection by the HR teams of the employer, they don't require consent of the employees. However, if the data is processed by the company for some other purpose, there is some employee segregation to be done, some employee behavioral pattern to be done, some employee engagement activities to be carried out for which the data is to be processed. In that case, the consent might be required. It is only for attendance, payroll benefits, etc. Consent is not required. Then what are the general obligations of a data fiduciary? So hospitals are necessarily data fiduciary. They are required to maintain the security and safeguards. They have to implement appropriate technical and organizational measures. So as I said, cyber security is a subset of data privacy. Cyber security is not all. It is a subset. So you have to maintain appropriate technical and organizational measures for security, adopt reasonable security safeguards to protect personal data, prevent and report personal data breaches to the Data Protection Board and to the affected data principals. Then data lifecycle and transparency. The data fiduciary is obligated to erase the personal data upon completion of the purpose or withdrawal of the consent, publish contact details of data protection officer or grievance officer. So data protection officer is required in case of a significant data fiduciary, which I will deal in next slide. And grievance officer is required in case of each data fiduciary. So their details have to be published. Establish effective grievance redressal mechanism. So it's not only enough to have a grievance officer, but also there should be an SOP as to how the grievances should be escalated and how they should be resolved. Processor accountability. Ensure that contractual safeguards with the data processors. So what happens is hospital keep sharing its data with various vendors and service providers, and the contracts which the hospital enters into, which the service provider should contain contractual safeguards which protect the privacy of the individuals, and they should have at least the similar obligations which the data fiduciary has towards the data principals, that is the patients. Remain accountable for processing carried out by data processors, because the hospital is accountable for the processes carried out by its vendors. It has to be accountable. Then significant data fiduciary. So the central government may notify certain data fiduciaries as significant data fiduciaries. And the criteria of notifying certain fiduciaries as significant is the volume and sensitivity of personal data which they handle, the risk to the rights of data principals, the potential impact on sovereignty and integrity of the India, security of the state, public order, or electoral democracy. On these grounds, it will be evaluated by the central government as to what is the magnitude of data which you are handling. I think large hospitals can come under the definition of significant data fiduciaries, and there is a heightened responsibility, enhanced obligation for significant data fiduciaries. They have to appoint a data protection officer who should be based in India. The officer should be responsible to the board of directors for compliance and grievance redressal. They must appoint an independent data auditor to evaluate the compliance. Significant data fiduciaries are also obliged to conduct periodical data impact assessment audit as to how the data can be impacted by the processes which the hospital follows. If there is a breach, what is the mechanism which the hospital implements? So those assessments of data impact have to be carried out periodically by the significant data fiduciaries. And significant data fiduciaries must undertake regular compliance audits. So compliance audit is a must have responsibility of significant data fiduciaries. Then the shared responsibility between hospitals and vendors. Hospital is the data fiduciary, as I earlier said. HMIS vendors, marketers, call centers, they are data processors. So call centers contain the data of the patients. They contain their names, their mobile numbers, their treatment, what treatment they have taken in past. So these service providers are the data processors. Hospital remains accountable for the vendor failures. If there is a failure by a vendor, the hospital is accountable for that. Then vendor contracts and audits become critical, because the clauses of the vendor contracts should cast responsibility back to back on the vendors, which responsibilities the data fiduciary carries on towards the patients. So these contracts become very crucial, and audits also become very critical. Audits of the vendors. So the data fiduciaries, that is the hospitals, should carry out the audits of the processes of these service providers and verify whether they have reasonable security measures, whether they have accountable measures, whether they have within their organization, the data is shared only to certain set of people who are actually required to have access to the data. So these audits should be carried out by the data fiduciaries from time to time with the vendors, so that there is no surprise to the data fiduciary for the breach by the vendor. And these are the penalties, very high penalties, which are contained in the schedule to the Data Protection Act. So breach in observing the obligations under subsection 5 of section 8, they may extend to 250 crore rupees per breach. So these penalties range from 50 crore up to 250 crore. So as you can see, a single breach, if it is taken seriously by the Data Protection Board of India, they can erode the entire EBITDA of an organization. So this is that serious. Then breach in observing obligations to give the board or affected data principal a notice, which is the breach notification, that may call for 200 crore rupees. Breach in observance of additional obligations, which is there are additional obligations in relation to children data. So children data requires calls for certain obligations like verifiable parental consent, then not tracking the locations of the children, then not surveillance over the children. So all those obligations are there in relation to children data under section 9. So if there is a breach, it may call for 200 crore rupees. Breach in observance of additional obligations of a significant data fiduciary. So significant data fiduciary is under section 10, which I just discussed. They may call for 150 crore rupees of penalty. Breach in observance of the duties under section 15. These are the duties which these are duties of the data principal rather. So they may extend to 10,000 rupees duties of the data principal. Breach of any term voluntary undertaking accepted by the board under section 32. This may extend to breach, which is mentioned under section 27 where instituted. Breach of any other provision of this act may extend to 50 crore rupees. So these are very significant penalties. These are maximum. Of course, the data protection board will not implement at once these much of penalties. They will certainly give an opportunity of being heard. They will evaluate the impact caused by the breach on the data principal. They will also evaluate the reasonable practices implemented by the data fiduciary. They will also evaluate whether the data fiduciary has taken reasonable measures to prevent that breach and to mitigate the consequences of the breach. So the measures implemented, the precautions taken, the impact caused, the loss to the data principal, all these factors will be evaluated by the data protection board, and then this penalty will be imposed. I don't think they will go to a extreme end of the penalty, but we should be mindful of these penalties because they may extend to this. I think in this session, this is my last slide because my next slides, all of them deal with the practical implementation, how the roadmap should be towards practical implementation of the data protection good practices. I will deal with that in my next session. However, there are 4 areas in which the compliance mindset should be. So compliance is not just a paperwork, it is a process, and that process should be embedded process in the entire governance of the organization. So it's not just a paperwork, it's a embedded process. We should focus on systems, people, and vendors together. The systems which we are following should be looked at once again as to whether they are privacy oriented. The training of people, the education of people, and making them aware of this act and its requirements and the consequences which the organization may face, and also educating the vendors and making them accountable towards the breach. This should be a united approach, and this approach should flow top down. I mean, the top management should first be serious about this act, and it should percolate from top down approach, from the top management to the lower levels, that this needs to be adhered to. Then create privacy aware workflows. The workflows should be such that at each touch point of personal data, there should be an awareness whether I am causing breach of privacy of an individual. That awareness should be there in the workflows, and there need not be a fear. However, there should be a trust oriented approach, that the patients always have trust on the hospitals and healthcare providers, and there is an opportunity of enhancing that trust by implementing the provisions of the DPDP Act. So that building trust and not fear is an important factor in this. If we implement this four-way approach, I think implementation of Data Protection Act and good practices is not that difficult. And I am sure that the rules and regulations and the notifications which the Data Protection Board will issue in future will not be so harsh that they will be having vengeance against any of the healthcare providers. However, we should be mindful of the bullet which is coming towards us, and we should be ready and prepared to be fully compliant with this legislation. With this, I think I stop here with my first session. In the second session, I will take you through the practical approach and how it should be implemented at hospitals and healthcare providers. Thank you so much.
Thank you so much, sir. This was a very insightful, an exceptionally insightful and enriching session. So we have some, say about 5 minutes left for the question and answers. If there are any questions, I'll be happy to take them up. You can raise your hands, please. All right, I'll let Mr. Suraj Kumar, if you have a question, please.
Yeah, thank you. Thank you, Dr. Priyanka, Dr. Amit. This is really a very insightful session. I just wanted to understand how this joint data fiduciary will be explicitly called out on the contract, and how a joint data fiduciary will be equally accountable for any of the data process which they are doing on behalf of the data fiduciary.
Yes. So if you see, this is not a new principle. Even GDPR contains clauses for standard contractual clauses, SCCs. So the hospitals should take expert advice of their legal team, and if they don't have legal teams, they should take expert advice of lawyers for drafting and negotiating the clauses of contracts with their data processors. Those clauses should contain obligations like, in case of handling of personal data and processing of personal data, the principles of data minimization, purpose limitation, storage limitation, those principles, there are multiple 6 or 7 principles which should be embedded in the contract which the data fiduciaries will enter into with the data processors. Not only that, but also in case of a breach, how it should be mitigated, how it should be notified, and how the processor should take responsibility of the breach. So those clauses drafting is a legal work, and we should take advice of legal experts while drafting the contractual clauses.
Oh, thank you. At the same time, since the government has pushes all the healthcare provider to get impaneled with the ABDM or the ABHA integration, at the same time, which all data processor will equally liable for the joint data fiduciary, in terms of like they are processing our data on behalf of the hospitals to the ABHA and ABDM central repository. So at that point in time, if any of the breaches happened, who will be liable for that? As a data fiduciary or the joint data fiduciary?
It is always the data fiduciary who is liable to the data principal. However, we can have back-to-back clauses with the data processor. But the government schemes which are being implemented through enrollment of the patients on certain benefits which the government passes to the data principals, that will be exempted, because the act has certain exemptions that if it is collected and processed for giving certain subsidies or benefits to the data principals, in that case the consent is not required. So government collection of data for passing on the benefits and schemes of the government is exempted.
Thank you.
Thank you.
Thank you, sir. We'll move on to the next question. Mr. Keval Kovekar. Please go ahead.
Sir, I have just started up a new company for just managing MRD records for the hospital which has no MRD department. So I provided digital and physical both services. So I'm not just new in that. I want to know that is the DPDP, that certification which we are recently been talking, that we require to I have to acquire from some certain place, or it will be from a server where I stored my data.
What certification?
DPDP Act for certification, or ISO 2700001.
No, so certification agencies are there who certify, who confer the certification. ISO certification accredited agencies confer certifications on you. That is the requirement for processing the personal data. However, in your case, the fiduciary is the hospital who collects the data from the patients. You are not accountable to the patients. You are accountable to the data fiduciary. But the data fiduciary should ensure that you comply with the certification requirements, so that the data fiduciary can implement best practices between him and you.
As per now I just to do some research. I'm using a server of Amazon AWS. That they have already that kind of certificate, both certificate DPDP and this also ISO. So I have to I need to acquire this certificate. I think I don't require, no? Maybe.
No. See, Amazon and all, they are different. They are just storage servers.
Yes.
You are processing the personal data, so you are required to get yourself certified. Amazon processes are different, your processes are different. You are required to provide certain services to the data fiduciary. So as a part of your contract with the data fiduciary, if you are required to provide certain services, you should get certified. You can't take benefit of Amazon's certification.
Okay, got it. Okay, sure. Got my answer.
Thank you. Thank you. We'll quickly move on to the next, probably the last question for today, because we're just about in time. The next question, I think, by Dr. Rishikesh Kalgonkar, is it mandatory to appoint a DPO, and who can be a DPO?
Yeah, so
do you wish to answer that in the upcoming session, sir?
No, just a small question. DPO is not mandatory for regular data fiduciaries. DPO is mandatory for significant data fiduciaries, and DPO should possess certain legal qualifications and should be responsible to the board of directors. However, grievance officer is mandatory for each data fiduciary. Within the organization, there should be a grievance officer who need not be legally qualified, but who will take the grievances and whose details should be published in the privacy policy and on the website. So DPO is not mandatory for everyone. It is mandatory only for significant data fiduciaries.
Right. We have some questions in the chat. If I may take them up, Dr. Amit. May I?
No, I have no issues.
All right. Is the Digital Personal Data Protection Act applicable only to hospital, or does it extend to all the healthcare services?
It is applicable to everyone, not only hospitals. It is applicable to individuals, to partnership firms, to hospitals, to whoever whoever processes digital personal data, the act is applicable. It is even applicable to state. So state is also, there is a definition of person under this act, and person covers everything. Even HUF is a person. So it is applicable to everyone. Whoever collects and processes data, it is applicable.
The next one in the chat is how to verify if the HIS vendor is complying the DPP Act.
You have to carry out audit. You have to appoint experts and carry out audit of your vendor.
The next one by Dr. Archit Chaturvedi. I'm sorry, I'm going a little fast. I'm trying to cover up as many questions as possible. Is by, can you please provide your view on electronic health record notification 2016 and whether the support rule 6 requirements under DPDP?
Yes, the notifications rules will be governed, and those notifications will be covered under this act, and act very much covers it. If there is a conflict between the electronic notification rules and the DPDP Act, there is a specific provision under the act that the DPDP Act prevails over any law which is in conflict with the act.
Sorry. The next one is probably I'll move on to quickly finish the next questions. I'm sorry. I'm really sorry. Yeah, Dr. Joseph, if you can, yeah, ask your questions.
Dr. Amit,
Yes.
the session was a very good one, but I want to ask you one thing. When the hospitals rent out their services like domiciliary care services and the patient feedback which they were taking on behalf of the hospital, especially when with a group of hospitals, how the data privacy and the fiduciary will, whether it's rest on the hospital or rest on the third party who is doing the same?
It will rest on who's billing. If you are billing the patient, you are the data fiduciary. To whoever you outsource the service is the data processor. Whoever is collecting the money, that's the data fiduciary.
There is one more addition. There is a clause in patient right in NABH healthcare organization standard, which says that the treating information be confidential and patient can decide to whom it should be carried out. But in case of domiciliary care, how it is ensured then?
I think that standard can be better answered by NABH. I'm not expert in NABH standards.
Okay,
The
thank you.
question is, yeah.
Okay, thank you. Thank you, Priyanka.
Thank you, sir. Moving on to Ms. Veena, would you like to ask your question?
Yeah. So, Dr. Amit, we have received one case wherein currently, when there is any of the patient data, be it a bill receipt or be it a lab report, we send to the patient for their accessibility. So, once if the patient want to access that document, they need to enter the OTP that comes into their mobile number for verification purpose. Once the OTP is correct, then they can access their document. So now we have received one of the requests from our client that they need to bypass this OTP process. So will this lead to security concerns? Should we not advise them to do so, or should we restrict this OTP to some level of reports like lab report? We should consider OTP for bills and receipts. We should not. We need your suggestions, please.
So by client, do you mean the patient?
Uh,
You said
so
request has come from the client. Who's the
from
client?
from our clients who are using our HMIS.
No, I think it is a good feature, and it ensures that only the person to whom the data relates has access to the bills.
Correct.
Okay. So that bypassing should not be accepted.
All right. Thank you for your inputs. Yeah.
Right. The next one in queue is Ms. Bhavya from ISAR Center. I think she has a question. What are the requirements for telemedicine as per DPDP Act? I think her question is, what are the requirements for telemedicine as per DPDP?
I think the
Yes, it is.
question is not clear. What are the requirements of telemedicine? I mean, you mean that uh, administering medicines through remote consultation? Is that what
Yes,
is the
sir.
meaning
Yes.
of the?
Yes, sir.
So is it through video conferencing or only audio calls or what?
So video conferencing and audio. So what are the requirements as per DPDP Act?
See, if you're administering some medical treatment remotely and thereby you're collecting certain information while administering, you're accepting certain forms to be filled in or certain information to be provided to you, or you're recording the session, telemedicine session, and storing in your system, then under the DPDP Act, if you're recording a session with a particular patient or taking his information and storing in your device, then that information should be accessible only to the people who are required to access that information for giving treatment to the patient. The purpose needs to be identified, why the patient is giving the information to you for the treatment. So that purpose oriented approach should be there, and whatever is required for the achievement of that purpose, only those things should be done, only those people should have access. At the same time, you should take upfront consents from the patients and give notices that you will be using this information for this purpose, and you should take specific consents from the patients when you onboard a patient for this telemedicine services, so that in future you should not land in a scenario where the patient says that I had not given consent for this purpose. So those consents and notices should be in place, and they should be maintained. Those logs of consents and notices should be maintained in your system.
Okay, thank you, sir.
Right.
Thank you.
The next question, Mr. Archit Chaturvedi. Would you like to go next, please?
I think that's the hand which he had raised earlier, and he asked a question.
Okay. We have another question in the chat. Can by Dr. Ranjit Christopher, can insurance indemnification help us, and to what extent?
No, indemnification helps for enforcing the contractual clauses between you and the insurance service provider. It will definitely help to the extent your clause is robust and it indemnifies you to whatever extent it is mentioned in the clause. That is definitely helpful if it comes to a dispute before the court of law between you and the insurance service provider. To that extent, it will help. And that's what I was suggesting when I say that there should be robust contractual clauses between the data fiduciaries and the data processors, because insurance provider is a processor here. If the information is directly provided by the patient to the insurance company, then in that case, the insurance company becomes data fiduciary. However, if the information is routed through you and you are the collector and you provide information to the insurance company, in that case, you are fiduciary and insurance company is the data processor.
Right. Ms. Bhave, do you have another question? I see your hand raised again.
Yes, ma'am. It's more of a follow-up question as to what sir had stated earlier. So what is the retention policy, or is there anything specific for the retention policy for such consents when conducting telemedicine? As sir said that there should be consents, specific consents while doing telemedicine. So is there a specific
Yes.
retention period for that?
Yeah, so retention of data, right?
Yes, sir. Yes, sir.
Patient data. Yeah. So
Yes,
what
sir.
happens is OPD data is to be preserved. There are notifications issued by the Indian Medical Council and the National Medical Council that OPD data to be preserved, and I think I remember that it is to be preserved for a period of 1 year. IPD data is to be preserved for a period of 3 years, and medical legal data, wherever there is a police case or any legal matter is involved, in case of patient data, then that data should be preserved forever, because the legal battle can go on forever and it can go on up to Supreme Court. So these are the larger categories: 1 year, 3 year, and forever. But if there is some other law which requires retention for a longer period, like for clinical trials, there are ethics committees who require the data to be retained for 7 years. So the Data Protection Act contains specific provisions, and it excludes that if any law which requires retention for a longer period, such data can be retained. However, if it is not required, then it has to be erased as soon as the purpose is served, but not before 1 year, because 1 year is a period till what time the data has to be retained.
Thank you, sir.
Thank you.
Still see some hand raised, though I think those questions were answered. If anyone has those questions, what about birth file? Asking about birth file.
Question is not clear. I mean, what about
Dr.
birth
Rishikesh,
file?
would you like to elaborate that question?
No, it is not my question. My question is different. I want to ask one new question.
Yes, please
Yeah,
go on.
please go ahead.
Okay, namaste, Dr. Khatu. My question is, the NMC has published some guidelines in 2023 for RMP and for their professional conduct, and they have explicitly explained or had their guidelines that RMP should not use social media for patient testimonials and should not share the patient's reports on social media. So it is just a guideline, or it can be seen as a data breach in this DPDP Act?
No, that's different. That's a medical ethics guideline issued for best practices of registered medical practitioners. Those guidelines were notified and they contained several social media restrictions, which were ultimately objected by the association, Indian Medical Association, and they went on hold and they are in abeyance right now. The previous guidelines which were issued in past today prevail. However, that has nothing to do with the Data Protection Act. It is a complete code in itself. The Data Protection Act is complete code. The social media guidelines are different. They have nothing to do with the Data Protection Act.
Okay, thank you, sir.
I think we've answered all the questions, and quite a engage in an active engagement and thoughtful questions. So we sincerely thank all the participants for active engagement and thoughtful questions. And thank you once again, Dr. Amit, for an exceptionally insightful and enriching session. Your practical guidance and clarity on DPDP compliance have really provided with valuable directions for the hospital navigating this evolving regulatory landscape. We're pleased to share that part 2 of this webinar will soon be coming up in the coming weeks, where we will further dwell into advanced compliance strategies and practical aspects of the implementation. So we look forward to part 2 of this DPDP webinar sessions. Thank you so much, sir, once again. And thank you so much to the audience here. I think it was a wonderful participation. Yeah. Thank you so much.
Thank you. Thank you so much, Dr. Priyanka. Thank you, everyone.
Thank you, Priyanka.
Thank you all.
Thank you.
Thank you.
Thank you.